This is Bloomberg Law with June Grasso from Bloomberg Radio.
It's a pretty bad deal. So the core issue here was that Live Nation and Ticketmaster, when they merged a few years back, they became so powerful that they were able to raise ticket prices.
Republican and Democratic attorneys general are among those who are not happy with the Justice Department's sudden mid-trial settlement of its landmark antitrust case against Live Nation. North Carolina Attorney General Jeff Jackson says it's a bad deal that keeps Live Nation's monopoly in place.
The vast majority of the AGs who started on this lawsuit are going to stay on this lawsuit. That's Republicans and Democrats, a couple dozen of us from across the country. We're working out the timeline, but we've told Live Nation they can expect to see us back in court very soon.
Perhaps as soon as Monday, if settlement talks ordered by the federal trial judge go nowhere. Joining me is antitrust law expert Harry First, a professor at NYU Law School. Harry, let's start with the trial judge's reaction to this surprise settlement of the Justice Department with Live Nation. The judge scolded everyone at a hearing on Tuesday. He said the DOJ's lack of transparency about its settlement negotiations was mind-boggling and that the parties' conduct here strains the bounds of acceptable conduct. I mean, 4 days into the trial, the secrecy, what's up?
Well, these are great questions. You know, we can speculate. I'm glad to speculate, but we don't know for sure. Here's my guess. My guess is the trial staff, they have really top people trying this case. My guess is they were blindsided. My guess is that they were not involved in this settlement. Just a guess. These are real long-serving professionals, both in and out of the Justice Department. I think that this was done above them. That's a guess. And the term sheet, I've never seen, this is the crazy term sheet. What is this, a deal? The term sheet is signed by the acting assistant attorney general, not by anyone on the trial staff. And, you know, for this to become what's called a consent decree that the judge enters, it's got to look a little more formal than this. So whether they'll sign it or not, I think would be a good question. And I don't know. I think that's to look forward to. And blaming the states, I would be close to certain that the states were completely out of the loop on this. I think everyone was concerned that this case was going to be sold out. And I mean sold out in the literal sense that this was a political deal and, you know, whether it's actual money changing hands or just straight lobbying, that this is another example of, you know, something happening like that. And, you know, people were watching this case to see if it was ever going to go to trial, you know, whether it would be settled out before with exactly the thing that we see, which is that Live Nation doesn't have to give up Ticketmaster.
The settlement doesn't address the main relief sought in the case, which is Live Nation selling its Ticketmaster subsidiary. I mean, that was at the center of the case. So what does the public get from this settlement?
A little bit older and deeper in debt. Wasn't that the song? I don't think the public interest is served by this. I don't think the public gets very much. There may be some money. Who knows how much? The states have to agree to it. There's some pullback. It wasn't clear who owns what in these arenas. I don't know exactly. They were negotiating the terms, you know, Sunday night before this term sheet was released. So it really isn't clear. And if they have to, you know, go back on some of the contracts, the exclusivity, the problem is not in the formal contracts. The problem is in the economics of this business and tying the ticket sellers to the talent. I mean, that's what it is. And you're not going to solve it by saying, excuse me, don't insist on a contract. That's where they started out in 2010. It never worked and it never will work. So it's just really not something to advance the public interest. The second part is some access to Ticketmaster's API, so some other ticketing company can do something. They actually tried this before. That was part of the 2010 settlement. And one of the things that happened is the company that was supposed to be given access to it didn't want it. I mean, it's failed. And it fails because venues will not want to offend Live Nation by using a different ticketing company. And Live Nation has said, they said in testimony, they said, we're going to make the choice that makes us the most money. Guess what? So it's sad, but overlaying it is this question of political influence, which has been the song of antitrust from the beginning. And here we are again, I think.
39 state attorneys general are also part of the case, and 27 states and D.C. asked for a mistrial and also for 60 days so that their attorneys can try to get up to speed to try the case because the Justice Department was the lead on the case. So the judge didn't rule on the mistrial motion, but he required the top officials to stay in the courthouse for the rest of the week and try to hammer out a deal. I mean, what are the chances of a deal? 0 to what?
Well, you never know on these things. I mean, the states are now in a tough spot. They were sitting there watching the trial. They knew that this could blow up at any point. I don't think they're surprised in that sense. But, of course, there's a difference between sitting there watching the trial and stepping, up there and trying the case. And it's before a jury. I don't know how it goes when, you can see why they'd want a mistrial, not want to have to come before the jury without the Justice Department there and say, hi, we're your new friends. You remember those other folks? Do you explain this to you? I don't know how exactly that would work. This is really weird. There have been cases, one case in which I'm familiar is the Microsoft case where states and the federal government tried the case together, and then the Justice Department settled with Microsoft, but not all the states did, and they continued to litigate the remedy, but not, whether there's liability. So still a little different. Didn't go so well for them. So it's hard. They're in a hard position. Maybe they can eke out some more or something from Live Nation, although I bet they don't. And, they either are going to have to join the settlement or go it alone. I think the judge is not going to be too happy about a mistrial and starting over again. And the only reason to do it, there are two reasons. One is to get good law made, is to get a verdict against Live Nation and Ticketmaster. It will help in some other private litigation. Maybe not so much help, but a little. And the second is that relief to get divestiture. And, maybe they can make the case, if they've got the right experts, that this is the only way to solve this problem and to have competition in ticketing is to change the incentives of the parties in this industry.
If you talk about, politics and the politics of the states, for example, New York Attorney General Letitia James has said that at least 25 states and D.C. are going to continue with the trial. The idea of this suit is also popular with the public because buying concert tickets has become a luxury item. Every time you go to buy tickets on Ticketmaster, it seems like the prices have climbed yet again. So what do the states have to lose by going forward with the trial?
Well, part of the answer is that the remedy of splitting them apart will not, the day after produce lower ticket prices. It's a market process, and you hope that new companies will enter the ticketing business particularly and bring some competition there. But, Taylor Swift concerts are still going to be really expensive, and there'll still be resale markets. And so it's a slow fix. So, yes, it looks attractive from the point of view of the states, and, pushing on and being in the public interest. But it is a longer-term public interest. So maybe there's some quick fix or something. Everybody who bought a Taylor Swift ticket gets a free album. I don't know. Get some money. So maybe they'll increase the money in the pot. There's a lot of money here.
So when the judge rejected the request and said that if the parties truly want to settle, a deal could be made within a week, and the in-house attorney for Live Nation, Dan Wall, said, I've done this for 45 years and there's zero chance we get this done by Friday. And the judge said, not with that attitude.
I love that. That was great. Yeah. Dan Wall is very sure of himself, let's say. But the states have now apparently hired a very, very successful antitrust trial lawyer, Jeffrey Kessler. It's a smart, sharp move. So they're not looking to, just vanish. But they are up against a difficult tactical position here, and they have to be sure that they really want to go ahead and push for divestiture. It's not impossible, but the states don't generally do so well once they've been deserted by the Justice Department. There are past cases, not always, but it's hard. Now, they need the experts, the economists and industry experts, and they need a top lawyer, I guess. They have good lawyers in-house, but they've hired, a guy who could go up against Dan Wall.
If there's no settlement, the judge says the trial is going to restart on Monday with the same jury. It seems very difficult for the states to just pick up now if the judge doesn't give them more time. Okay, on Monday we're in court when, we haven't been prepping the witnesses. We haven't been doing this.
Yeah, I don't know. I don't know how actively involved they've been in trial prep or how much. There's always an underlying tension between the states and the feds, even when they're trying cases together. Playing with your friends doesn't always go smoothly, even if you're good friends. But my guess also is that the professionals on the staff, the trial staff, will not be the roadblocks. But the front office, who knows what they'll do with the witnesses they've got and the information they've got, and how hard they'll make it for the states. I don't know. To add one other thing in there, in February, the head of the Antitrust Division was fired.
I was going to ask you about that.
Yes.
Where the Antitrust Division is going in Trump's second administration.
Yeah. Well, my speculation was that she was told that she was going to have to settle this case, and she refused. This really is speculation. I haven't read any reporting about it. In the grand scheme of things, this barely caused a ripple, in the world. So the reporting was that she was fired, not that she quit. So all of this sort of fits together in light of some other things that have happened in antitrust, as well as, of course, the broader world.
I mean, the judge can always reject the settlement, right?
So there's a legal process for the settlement itself. They have to file what's called a competitive impact statement. They have to let it open for public comment for a period of time. Then there's a hearing before the judge. It's called the Talley Act. And the judge has to approve the settlement as in the public interest. Now, that, as it's been interpreted over time, does not give the judge, the broadest power to say, this is a crappy settlement. Forget it. I want you to try this case. But the judge does have some power, and this will certainly provoke a lot of public comment. And that's a process that will go forward while the case is being tried, apparently. I mean, there are, I forget the exact time, but let's say 30 or 60 days for comment. This has to be put into a formal decree. Yes, and the judge has to eventually review it and approve it. And then it can be appealed, actually. So we're not at the end of this process.
What do you make of the judge telling the attorneys for Live Nation and the government, this is it. You can't go back on this now?
Well, because, the second step in this could be that the Justice Department moves to dismiss its complaint. Doesn't even go through the formal process. We've seen that, where the Justice Department just says, bye. We haven't seen it in antitrust cases, because the antitrust professionals really don't want to see a case where parties promise to do something, but it's not backed up with a court decree, this consent decree. So I don't really predict it here unless, I've been pretty bad at predicting things, so don't hold me to this one.
I don't know about that. I'll have to look back at your score. Also, under this agreement, the government could sue them again.
So as it's written, this is not, we're forever done. It's hard to know what to make of that. I mean, the government they did sue in 2010 when Ticketmaster acquired Live Nation and entered into a consent decree. They re-upped the consent decree in 2019, where they threatened to sue again. And then this is a suit with a different legal theory that they filed in 2024. So the standard rule is the government is not stopped from, unless they've signed a piece of paper, from bringing a new suit. So the answer to that is yes, they could bring another suit. I mean, in a way, it's cold comfort. We've now had from 2010 to 2026 this monopoly. It's, they've made a lot of money off of this. So thank you very much. We could eventually sue them at some point. When?
This settlement is actually turning out to be more interesting than the trial in some ways. Thanks so much, Harry, for your insights. That's Professor Harry First of NYU Law School. Prediction market platforms have soared in popularity in recent years, testing legal and regulatory norms like never before. Although most have drawn a line at one category, direct wagers on war. In fact, betting on war is prohibited in the United States, as is insider trading. Despite that, it seems to be flourishing on Polymarket, one of the world's largest prediction markets, whose main exchange operates offshore and outside the oversight of U.S. regulators. And now blockchain analysts have flagged suspicious activity, and lawmakers are calling for a crackdown. Why? The day before the U.S. and Israel launched an attack on Iran, there was a surge in big bets on Polymarket that correctly predicted the strike would happen the next day. Bubble Maps, a Paris-based company that tracks data on crypto transactions, identified what it called 6 suspected insiders who made a $1.2 million wager that correctly predicted the U.S. would strike Iran. Joining me is business law professor Eric Talley of Columbia Law School. He's the co-host of the Beyond Unprecedented podcast. Eric, tell us about the bets on Polymarket that are causing concern.
Yeah, so Polymarket is one of 2 major event-driven contract websites that people use that are basically prediction market, sort of platforms. And both Polymarket and Kalshi had various types of events, including events that might occur in Iran. And many of those pertained to the continued integrity of the Ayatollah Khamenei's regime in Iran and whether it would still be, in power, say by the end of February or by the end of the first week of March. And these were essentially binary bets. They call them contracts, but they're essentially bets where you can bet on yes or bet on no. And it became pretty apparent in the hours before the Israeli and U.S. strike on Iran that ended up killing both Ayatollah Khamenei and many other senior members of the Iranian government, that there had been a lot of activity that was essentially betting against the continuing viability of the Khamenei government past, in some future date. The interesting part about this, June, is that while there were a lot of bets that were being placed on this, most were small scale and kind of went on both sides of the transaction. But there were some really big ones that got placed literally within hours of the bombing that were all betting against the Ayatollah's fate. And all of them, at least purportedly, paid out. That gave rise, unsurprisingly, to a pretty significant kerfuffle about who created these brand new accounts. Why were they placing hundreds of thousands, even millions of dollars in betting on this particular event when these accounts hadn't made any bets before?
And Bubble Maps, which is a company that tracks data on crypto transactions, identified what it called 6 suspected insiders who made $1.2 million in wagers that the U.S. would strike Iran. Senator Chris Murphy was one of the people who said, it's insane that this is legal. And he said that the unusual betting suggested that even decision makers might have had a stake in the outcome, which the White House denied. But, insider trading?
Look, so a couple of points to pick apart in that statement. The first has to do with, is this in fact legal or not legal? Now, because prediction markets are new in the US, there's still a battle raging about how exactly these contracts get classified. I think most people think that they are a type of derivative contract. That's kind of my belief as well. They tend to have a lot of the look and feel of a lot of other call options, put options, various exotic auctions that you can buy and sell on the Chicago Mercantile Exchange. And so those are, in fact, to the extent that they are derivative contracts, they are, in fact, regulated by the Commodities Future Trading Commission, or CFTC. And that commission has a pretty robust insider trading prohibition that we can talk a little bit about the specifics of. But I think that the senator, all due respect, might be leaping to conclusions to say that this wasn't prohibited by law. In addition, there are a lot of state laws that might also sweep in to prohibit this type of inside trading that can also have criminal implications. So irrespective of, current bills pending in Congress, this is definitely something that I would expect that CFTC lawyers might be kicking the tires of. As to who did it, we still don't really know. We don't know who the owners of these accounts were. And, the fact of the matter is this could range from anyone from senior decision makers in the process, in the room making these decisions, to potentially mid-level staffers or even White House interns who were asked to run papers back and forth. One thing that's kind of interesting, June, is that I don't know whether you have a Polymarket or Kalshi account.
Absolutely not.
Yeah, I'm just going to say that there is a definite generational skew on who has these accounts. I have them, but the only reason that I have these accounts is that I teach finance to 24-year-olds, and they all have them. And so I have to kind of get inside their head to figure out, how I'm going to present the material. So I would say, yeah, it's certainly possible that senior leadership in the Trump administration White House was engaged in some of this trading. But I wouldn't be surprised if a 24-year-old intern wasn't also, asked to shuffle some papers back and forth, put two and two together, and then got on Kalshi and, borrowed a bunch of money to make a one-directional bet.
The CFTC has the authority to investigate this. But Michael Selig, the chair, came out in February saying that he sees the platforms as a way for society to channel the wisdom of crowds for useful information, offering a check on news media and other gatekeepers. And earlier this year, the CFTC withdrew a Biden-era effort to prevent Kalshi from accepting bets on the outcome of sports events and political elections. So first, does the CFTC have the authority here to look into this? And second, are they likely to?
Yeah, it's a fine point. And maybe backing up a little bit, one of the things that I have to, impress upon my law students is that formal legal differences don't always add up into substantive differences. So, one thing that I ask my students is, what's the difference between gambling, insurance, and buying and trading securities? And many valiantly attempt to distinguish them. But the fact of the matter is, June, they are all kind of the same type of a thing. They're regulated very differently. And so the boundaries of where one ends and one begins is really important from a legal perspective. But, really the biggest difference between, insurance, gambling, and securities trading is how exciting is the thing that you're trading on. And gambling is probably more exciting than any of them. The other thing, though, that is important to keep in mind is that while the CFTC, spokesperson certainly has a point to say that prediction markets are an important tool for marshaling the wisdom of the crowd, there are at least two important caveats to that. The first caveat is that if one allowed pretty much unbridled insider trading in these circumstances, then you and I, as people who don't have access to that type of inside information, are going to get wise to it pretty soon. And we're going to realize that any bet that we make on Kalshi or Polymarket, there's a good chance we're going to be on the losing side of it because we don't have as much information as the person that we are essentially trading with on that platform. And so one of the big conundrums with inside information and trying to see how quickly we can get it infused into the market is that if you basically say we're just taking the brakes off completely, that can have a feedback effect of causing all the uninformed people to say, I'm just going to sit this dance out. I don't trust these markets, and I'm not going to provide liquidity and depth to these markets. So that's one thing to worry about, that even if you believe this idea that the wisdom of crowds is really, really important for things like price discovery, and I do believe that, that doesn't necessarily imply that you should basically take all the brakes off of insider trading, because it can undermine that very market itself. The second thing that is probably worth keeping in mind is that there are bets and there are bets, right? So if you and I were to make a bet about, I don't know, Friday's temperature at noon in Botswana, that's something that, there will be a temperature reading. It will probably be trustworthy, and there is nothing that you or I could do to influence the nature of that outcome. On the other hand, if we are betting on whether, the Yankees pitcher is next going to throw a ball or a strike or a curveball or a fastball, and that pitcher himself is in, contact with folks who are making those sorts of bets, that's a highly manipulable decision. And there, the wisdom of crowds is almost self-defeating. As soon as the wisdom of crowds points in one direction, our hypothetical Yankees pitcher is going to have an incentive to pitch in the other direction and make money off of it. So there, in situations where the thing that is being bet upon is basically under the control of someone who is either participating in those markets or has connections to people that are participating in that market, there, I think people lose trust in these markets almost immediately, and they don't actually even serve this idea of aggregating preferences and beliefs in a very effective way. And so, where do we put things like bombing of Iran? That's kind of in the middle. It's a big decision. You and I probably don't have an awful lot of influence over it. But there may be a lot of people who either know about it and want to go out and make approximately infinity dollars off of the markets here, or are the decision makers in this area, which creates a second problem, right? Which is that as soon as they see money to be made by a particular decision, if they're engaged in these markets, do they have an incentive to change their decision so as to be able to cash out?
Just straighten one thing out for me. The CFTC does prohibit these prediction markets from listing markets related to war.
Right now, there is a prohibition in U.S. trading on various types of extremely sort of political type of events, but it's very hazy. And so sometimes, something on the periphery, like, will this administration be around in 4 months? That's going to be something that gets wrapped up in war as well. And so, I think that we're in the middle of this kind of process where these platforms are trying to figure out, what can we allow and what should we disallow on these platforms in ways that make people both participate and trust these platforms as not basically being a sucker's play for people that don't have inside information. And that's going to be very much in Kalshi's and Polymarket's interests to try to do that, but they're hardly ever going to be able to get it right. And a lot of times, the underlying nature of these securities bet, if you will, are essentially going to be around the fringes of what the designers of Kalshi and Polymarket are capable of anticipating in advance.
Kalshi faced backlash over a multi-million-dollar market on whether Khomeini would be ousted, and they actually issued refunds on the market, citing regulations barring wagers on death.
Yeah.
So they self-regulated?
They sort of self-regulated. And, I think that there is, in some ways, because a lot of these bets were very, very one-sided, Kalshi actually, faced possibly a little bit of exposure on this as well. And so I think, some people are trying to say, was this Kalshi basically trying to cover their own backsides, or were they legitimately trying to enforce a prohibition on various types of effectively what becomes wagering at the platform level? Where they ended up sort of coming down was this sort of, I think, a little bit of a messy distinction between, were they going to pay off at all? And if they were they going to pay off only a portion of the wager that was put down? And I think that, created a lot of ire amongst their clients who felt, maybe some of them honestly were, making a wager in a direction that paid off and they didn't have any inside information on, and suddenly they were getting shortchanged on it. By the same token, these platforms absolutely have an incentive not to develop a reputation as being kind of the place where suckers go to lose their money.
Coming up next, what about possible prosecutions? This is Bloomberg. I've been talking to Columbia Law School professor Eric Talley about the controversy over bets placed on the prediction market platform Polymarket, correctly predicting the U.S. strike on Iran. So in February, Israeli authorities arrested several people and charged two, a civilian and a military reservist, with using classified information to place bets on Polymarket. Anyone in the U.S. who used classified information to place a bet, would be subject to criminal prosecution, right? Is anybody looking into that? Is there an agency besides the CFTC?
I'm pretty positive there are some state attorneys general that are looking at this as well. One of the things that's kind of interesting about this, June, is that it gets a little bit into the details of how insider trading law works. And there are a couple of theories behind it, but the one that would most likely apply to this situation is something that lawyers call the misappropriation theory. And what it basically means is if my employer or someone with whom I have some kind of a relationship of trust and confidence reveals inside information to me, that is going to happen with either the stated or implied restriction that I have to keep that confidential. So if I go out and trade on it, then I have breached that confidentiality. And that is effectively what triggers a lot of criminal and civil liability for insider trading. The fact that I've misappropriated, I've violated this order or this command of confidentiality that came from the source. Maybe it's my employer or someone else. But the thing that's always been weird about this theory, and that applies also in the derivatives context, is that it hinges very, very critically on what does your employer permit and not permit, right? And so you could, in principle, have an employer who develops a lot of confidential information and their inside employee policies say, you know what, rather than paying you salaries, we're just going to let you trade rampantly on this inside information. And the third party suckers who trade with these informed folks, they have no idea even who they're trading with or what the inside policy is of the employer. But that's going to have a huge effect on whether there will be civil or criminal liability, whether there was such a prohibition. So you transport this over to the administration, in which clearly for classified information, there's both an implicit and an explicit prohibition on, trying to make money off of your own private knowledge of classified information. On the other hand, as we learned from the first Trump administration's, classified documents gate, right? There's a big question about, well, what constitutes classified and not classified, and who gets to determine when something is suddenly classified or declassified and when. And President Trump basically made the claim on behalf of himself that as he spirited these documents out of the White House at the end of his first administration, he basically declared, possibly to himself or possibly in passing, that they're all declassified now and therefore he doesn't have any liability. So query whether, some staffer or employee or, person higher up in the administration was placing some of these bets. The way that it would trigger, most directly insider trading prohibitions is because they were classified. If, President Trump said, oh, no, I declassified that in a meeting that I did it orally, but it's totally fine. Who knows what's going to happen there? Now, having said that, that doesn't necessarily take these folks off the hook for state level offenses. And there are some state level offenses that easily could be applied here. California, New York have pretty rigorous prohibitions on inside trading transactions. There are also various other types of provisions out there, the Wire Fraud Acts, the Computer Fraud and Abuse Act, that might also kind of play a peripheral role in this context. At the federal level, that's only going to be as strong as the stomach of the federal prosecutors who are going to bring these cases. And if they've gotten a command from on high that they shouldn't bring any of them, then I think we're going to be largely going to be left up to state attorneys general.
Are they difficult to investigate because the main prediction platform operates offshore? The bets are placed on the blockchain. The identities of the accounts making the trades are anonymous. I mean, let's say state attorneys general. Would it be difficult for them to get through all those layers?
Yeah, this has always been a difficult thing in investigating trades made on the blockchain. Compared to 10 years ago, it's much easier to trace the identity of who was making these trades. Where was this wallet created? Who did the creation of this wallet? It's possible to get that information. A lot of it would rest on subpoena power that might have to be applied extraterritorially, right, outside the country, because all these companies are based in Ireland or England or Europe and so forth. So that creates a stumbling block, not one that is necessarily insurmountable. I could certainly imagine various regulators inside the EU or the UK being equally worried about the use of prediction markets for insider trading and being perfectly willing to assist a request from, say, the New York State Attorney General or the California State Attorney General for some of that information, or at least to say, yeah, we were willing to serve your subpoena in Europe.
So finally, Eric, what do you think about, you talked about bills, and yesterday, Senator Adam Schiff, Democrat of California, introduced legislation seeking to explicitly ban any entity regulated by the CFTC from listing a contract that involves, relates to, or references terrorism, assassination, war, or death. I mean, what do you think about these bills? Long chances they go through, but if they did...
I think it's a valiant attempt by Senator Schiff. I think there's a couple things that are going to be challenges for it. So thing one is that if you take a look at that distinction that we talked about earlier between, events that no one has much control over practically versus events that decision makers do have control over, these things sit right in the middle, right? Terrorist events, war. In a lot of circumstances, those are completely extraneous events to a lot of the participants in these markets. And these markets, June, are also, potentially helpful ways to hedge various types of risk that you might bear, right? If you're running, a wholesale operation that requires shipping things through the Strait of Hormuz, and you're quite worried that war is basically going to shut down your business, having some type of insurance, or a more exciting version of insurance, right? Taking a position in these prediction markets might be a particularly good way to try to hedge those risks. So on some level, is this just going to push things back into insurance markets that may be less competitive than having more choices out there? So, I think that's going to be, potentially a problem. I think another one is, where exactly do you set the boundaries? Things like terrorism and war affect a lot of other things that don't at least optically look like they're terrorism and war, right? Like, does a prediction market contract that says, we're making predictions on how many ships are going to pass through the Strait of Hormuz, is it going to be more than 100 or less than 100, on a day in the month of April? Is that a war contract or is that a shipping contract, right? And, on some level, it could be both. And so I envision a lot of sort of, boundary marking that's going to be heavily freighted, and it's going to be easy to spot things that ended up on the permitted side of the boundary that pretty much look and walk and talk and act as though they're a bet on war or terrorism.
A lot more to come with these prediction platforms. Thanks so much, Eric. That's Professor Eric Talley of Columbia Law School. His podcast is called Beyond Unprecedented. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.